everyone. Thank you for being here. My name is Jocelyn Kennedy. I'm the Executive Director of the Law Library. I'm delighted to have you here for this event 50 years after Furman, the death penalty in America. I also want to thank my colleague Katie Beck, who's back here, who actually curated the library's exhibit, Visualizing Capital Punishment, Spectacle, Shame, and Sympathy, which is on view in the library's Casperson room throughout this summer, and it's also available online. And KB is the one who coordinated all of these events that we've had this year, so thank you, KB. And I would also like to point out that one of our speakers this afternoon, Michael Meltsner, has lent us his original briefs from Furman versus Georgia case, and those are also on view in the Casperson room, so we're pretty lucky to have that. This afternoon's conversation was moderated by Professor Carol Steiker, the law school's Henry J. Friendly Professor of Law. She's the Dean's Special Advisor for Public Service and the faculty sponsor of the Capital Punishment Clinic, and was the faculty co-director of the Harvard Criminal Justice Policy Program from 2015 to 2020. She specializes in the broad field of criminal justice with a special focus on capital punishment, and she recently served as an expert witness on behalf of the ACLU in a Kansas trial about whether it's possible to assemble fair and impartial juries in Kansas capital murder cases. Mugambi Jouet is an associate professor at the USC Gould School of Law and a former public defender in New York City. His academic research focuses on American exceptionalism, criminal justice, and comparative history from a multidisciplinary perspective. His article, Revolutionary Criminal Punishments, Treason, Mercy, and the American Revolution, notably won the 2021 Brophy Prize for the article in the American Journal of Legal History that, quote, most significantly breaks new ground and adds new insights to the study and understanding of United States legal history, end quote. On the 50th anniversary of Furman last year, he published an article in the American Journal of Criminal Law titled, A Lost Chapter in Death Penalty History, Furman versus Georgia, Albert Camus, and the Normative Challenge to a Capital Punishment. We're really excited to have you here. Corinna Lain is the S.D. Roberts and Sandra Moore Professor of Law at the University of Richmond School of Law, where she has been a professor for 21 years. She's been writing about the death penalty since 2007 and has published numerous articles, essays, and blog posts about the death penalty in general and lethal injection in particular. Professor Lane's work has appeared in the nation's top law journals, and she is a frequent presenter on death penalty at conferences worldwide. Professor Lain is a leading voice in criminal justice in Virginia. She trains members of the judiciary, the Virginia State Bar, and the Virginia Indigent Defense Commission, and she's finishing a book right now on lethal injection titled Secrets of the Killing State, The Untold Story of Lethal Injection. And described as the principal architect of the death penalty abolition movement in the United States, Michael Meltsner is the Matthews Distinguished University Professor of Law at the Northeastern University School of Law. Early in his career, Thurgood Marshall hired him as the first assistant counsel to the NAACP Legal Defense Fund. Professor Meltsner served as Dean of Northeastern University School of Law from 1979 until 1984 and has consulted and lectured throughout the world. After 5 years at Harvard Law School as a visiting professor and director of the first-year lawyering program, he returned to Northeastern in 2005. He received the Huger Badeau Award for Excellence in Death Penalty Scholarship and an honorary doctorate by John Jay College. In addition to his scholarly writings, Professor Meltsner has written a memoir, a play, and novels. In 2002, he published Mosaic, Who Paid for the Bullet, a novel about a forgotten civil rights era murder. With that introduction, I will turn it over to Professor Steiker to start our conversation. Thank you.
Thank you so much, Jocelyn. My great thanks to the library, to Jocelyn Kennedy, and to KB Beck, who have organized both the incredible exhibit, which I hope that all of you have seen or will go to see. It's on all year, and have organized a number of just really wonderful events around the exhibit this year. This one, is a gold-plated, gold star panel of tremendously interesting and influential lawyers and scholars in this area, and I'm just so thrilled to have them all together here for me to interrogate, and I use that word advisedly. Michael, I'm going to start with you, because you were there at the very beginning. In 1963, you and your LDF colleagues began the litigation campaign to end capital punishment that eventually led to Furman versus Georgia. The following year, you may have been the youngest lawyer to argue a capital case before the US Supreme Court, which you actually won. And you are still writing, consulting, and nagging other people about capital punishment 60 years later. Can you tell us something about the people that you worked with who may not be familiar to everyone in this audience? And if there is time, maybe some of the memorable events at these early days. I was in 5th grade.
Well, after that introduction, I feel like I shouldn't say anything because I can always only go downhill. So you don't launch a multi-year litigation campaign without a team backed by a wide range of allies and talented people. Of course, the key player in the abolition movement was and is Tony Amsterdam. But he's so well known that I'm not going to say a lot about him, but I want to refer anyone who's really interested in the details. There's a wonderful a profile of him in the autumn 2007 NYU Law magazine, and I have put about 10 copies of it over in that chair, which you can take with you if you're interested. So we rarely talk about the costs of capital defense, at least not in the 1960s and 70s. But my boss, Jack Greenberg, gave us the green light in 1963 before any major foundation would give money to capital punishment work. In the decade I was at the Legal Defense Fund, I was never told not to spend an amount of money for travel or printing or research. And a large reason for that is Jack Greenberg's skill. He had many others. He was the guy who came up with the money for the McCleskey-Baldus study. And it really all started with Jack when he and Thurgood Marshall tried what are known as the Groveland cases. If you're interested in civil rights history, you might check out Gilbert King's wonderful book about the Groveland cases, Devil in the Grove. So, you know, the backstory includes paying for things, and Jack made sure it happens. Anyone who has followed the capital punishment story from 63 to today is aware that the Supreme Court, in its wisdom, has avoided obvious evidence of racial discrimination at every point, although never really denying that it existed. The proof in this area began with a man named Marvin Wolfgang, who was the stellar leading criminologist in America. You will find that almost every person who's worked seriously on the death penalty issues over the years is talented. There are many, many talented people. I'll mention some of them. But there are two geniuses, and Tony Amsterdam is one, and Marvin Wolfgang, who you probably never heard of, or some people haven't heard of, is probably the other. He designed a 90-page schedule to show that there was really no difference other than race in the selection of when black and whites were selected for execution. You might think of him, because you probably have heard of the Baldus study that was involved in the McCleskey case in '87. You can think of Marvin as the grandfather of the Baldus study, because he began it. And he began it after something really unusual. In 1965, 27 or 8 law students were sent by us and by an organization called the Law Students Research Council to the South to collect the data about what really went on in Southern rape cases over at least a 10-year period. They were all white, and they presented themselves as just eager student researchers whose professors have sent them down there. And amazingly, they got the stuff. I was the person in New York sitting at the telephone waiting to hear that they got arrested, beaten, thrown out, and calls never came. They were just wonderful. And they got the information that Marvin then converted into the first real proof of discrimination. Well, one of them was a man named Forrester, who later became a judge in San Diego and Imperial County, California. And he wrote a manuscript called Race, Rape, and Injustice. And the manuscript was sent to me by the University of Tennessee Press, and as all academics know, you try and publish with the university press, and you have to go through hell because all sorts of academics have to read it and say, oh, well, it's not really good enough. So they sent this to me, and I said, well, you know, it's pretty good. We need some changes and so forth and so on. And then I didn't hear from them. And you know, maybe 2 or 3 months later, I wrote a little note to the editor, and I said, you know, what kind of happened here? I never heard back. And she wrote me and said, well, he died. And would you look at the manuscript and perhaps edit it a bit? And so I did. And so this is the book that emerged. It's not really well known, but it's very valuable, especially for the introduction, which I wrote. You know, the name of the game from 1963 to 1972, the moratorium strategy, which meant that there were no more executions after 67, was really getting stays of execution. And we did that because of creating a strategy which was built around a lot of procedural issues about the way capital cases were handled. It worked amazingly well, but there were really a few crisis points. And one of them was in Florida, where a new governor, not named DeSantis, was elected, named Claude Kirk. We're back in history. And maybe he set the tone, but he immediately announced he was going to sign every damn death warrant he could, and there were over 50 people on Florida's death row, at least. But he didn't know that he was facing a Elfin ACLU lawyer who was also a LDF cooperating lawyer named Tobias Simon. And Simon filed in a federal district court the first class action habeas corpus petition in legal history. Maybe I should amend that. You know, if you were a wife or you could maybe file for 2 people in habeas. This is the first class action. And believe it or not, he persuaded a federal judge to issue a stay. And so Toby flew to Cambridge, Massachusetts, along with Tony Amsterdam and Jack Greenberg, and they consulted with my great friend and mentor, Ben Kaplan, and Al Sachs, the former dean of this law school, both of whom had kind of written the parts of the federal rules that were involved. Can you imagine that? And they said, well, you know, this is a long shot, but give it a try. And in fact, it worked. Do I have time? I mean, am I running out of time?
I think I'm going to just I want to move around a little bit. I'll come
Oh,
back to
yeah,
you, Michael.
okay,
Is
okay.
that the chapter in your
I could
wonderful-
go on for a few hours, but,
I would love for you to
I
do
would
that,
too.
but we don't have
okay.
hours.
Anyway, it worked. Okay.
Amazingly well. I'm just going to put in a plug for your book, Michael. Is that the chapter called Simon's Folly?
Yes.
Cruel and Unusual?
You're well read, you know?
I'm very well read. Michael, 1 year after Furman versus Georgia, wrote a brilliant Inside the Litigation book about the litigation campaign that led up to Furman and the decision in Furman, and the chapter about the successful class action suit in Florida is a chapter called Simon's Folly in Cruel and Unusual. The book was reprinted, a second edition in 2011, first published in 1973, the year after Furman. And just the moratorium strategy, the LDF strategy, was to stop every execution in the United States with the idea that many European countries had already abolished the death penalty, and one of the things that proved successful is that if you had a period without executions, people began to realize, the sky didn't fall, we can live without the death penalty. So the LDF had this moratorium strategy, and the death penalty had already been declining in the early 1960s, down from, hundreds in the 30s, down to a dozen or so, in the early years per year, in the early years of the 1960s. But then the moratorium strategy led to 1967, 0 executions, 1968, 0, 1969, 0, 1970, 0, 1971, 0. So when the US Supreme Court considered the death penalty in Furman in 1972, there had already been 5 years with no executions in the United States. There were 600 and some odd people on death row stacked up, waiting nationwide, waiting to be executed, but the LDF had brought the American death penalty to its knees before Furman versus Georgia was decided. So it's a very, I don't think anyone could have predicted that. And if you had asked me, I was in 5th grade, I don't know that I would have had much to say, but I would have said, no way, that's not going to happen. But it's just such an exciting story. So, Mugambi, I want to pick up on a thread that Michael introduced us to, which is the role of race in the 1972 litigation. Like, the question presented to the court in Furman wasn't explicitly about race. But can you talk a little, can you tell us a little bit about what you take to be the role of race in the Furman litigation and decision?
Absolutely. One place to start is the distinction between Furman as a judicial decision and the litigation, especially the briefs filed in Furman and the companion case called Akins versus California, which presented the main challenge to the death penalty. Furman is best remembered as a case about the arbitrary, capricious, and racially discriminatory application of capital punishment. But that's not what was fundamentally argued in the briefs. The challenge in the briefs was one based on evolving standards of decency, which is the benchmark to interpret the Eighth Amendment of the US Constitution based on an influential precedent called Trope v. Dawes. And the arguments in the Furman and Akins briefs was fundamentally a humanistic argument, that it is inhumane to kill a prisoner in light of evolving standards of decency. The argument was not fundamentally about race or arbitrariness, and that can be understood by looking at the prior line of cases and challenges, which had actually tried to reach the abolition or pose a challenge to capital punishment based on race. In the case that Professor Michael Meltsner mentioned a moment ago, called Maxwell versus Bishop, there was this elaborate strategy with the criminologist Marvin Wolfgang to document patterns of racial discrimination in rape cases in the South, especially a case from Arkansas. And that was defeated by circuit court with a decision by Justice Harry Blackmun, who later on would become, of course, a key figure in death penalty history, just like in US constitutional history. So the fundamental challenge in Furman/Akins was one about the inhumanity of capital punishment, not about race. However, what was argued was also very sophisticated. What the LDF, Tony Amsterdam, Michael Meltsner, and colleagues argued was that the death penalty is inhumane, it's no longer accepted by the American people, is falling out of place in Western civilization, in Western democracies, sharing our commitments to liberty and humanity, and it only remains to be applied how to a few people who are selected arbitrarily, capriciously, and discriminatorily. And that's how the question of race came into the picture, that the few people who are selected to die are overwhelmingly underprivileged persons, from poor whites to African Americans, and that if the death penalty were applied more widely, systematically, it would not be acceptable to the American people, and they only tolerate it because a few persons, the pariahs of society, to quote Tony Amsterdam, are those who are set to be executed.
Yes, that's lovely. And Tony Amsterdam and Mike Meltsner, this argument appears very prominently in the briefs in Akins and Furman about how we only tolerate the death penalty because it's applied discriminatorily. If we applied it really equally and to a lot of white people, well, then no one would tolerate it. We wouldn't have the death penalty. What I find really interesting and ironic, I clerked many years later, not that many years later, but I clerked later for Justice Thurgood Marshall. And interestingly, in his opinion, every justice wrote his own opinion in Furman versus Georgia, and in Justice Marshall's opinion, he had a very different take. Justice Marshall said, the death penalty violates evolving standards of decency. He said, yes, if you ask people in a public opinion poll, they'll tell you they support the death penalty. But the real question we should ask, says Justice Marshall, is what would a fully informed person think? If they really knew all the facts about the death penalty, a fully informed person would reject the practice, which is kind of the opposite of what Amsterdam and Meltsner argued, because they argued we only reason we have the death penalty because we know it's not really going to be applied to everyone. And Justice Marshall said if people really knew how it's applied, they wouldn't support it. Well, I mean, that's just the opposite argument, is that they only supported it because they knew how it's applied, was the LDF argument. So it's interesting that the former head of the LDF took a much more, I think, optimistic view of human nature, that if people knew that the death penalty was discriminatorily applied, well, that would lead them to reject it as opposed to embrace it. So just a little LDF split there generationally. Corinna, I want to turn to you. The justices in Furman clearly thought that the death penalty was on its way out. As their comments and their concurring opinions and in conference made clear. Do you think the justices were wrong about where the country was on the death penalty, or do you think that their decision in Furman unwittingly changed public opinion about the death penalty?
Yeah, it's a great question, and it's one that scholars have debated. So my position is that that the justices weren't wrong, but that they that the decision in Furman itself unwittingly changed it. But I think what's really interesting is you see the justices in conference, they're talking about saying, like Justice Stewart and Justice White, who were the tough votes because they were the great dissenters of the Warren Court era, and you see them in conference saying, if we affirm these death sentences, it will only delay abolition. And then you think of Justice White in his concurring opinion. His entire vote was based on the fact that the death penalty wasn't being used enough to satisfy the penological goals that you would need, which made it cruel and unusual. So, key members definitely thought it was on its way out. And interestingly, if you look back at the original sources, at what the magazines were saying, so I was thinking the Supreme Court Review in 1972 said the inevitable came to pass. It was just, it got sort of this figurative yawn is what Furman got. And even in 1971 and 1972, when Furman was, when the court was considering Furman, you had Time Magazine and Newsweek talking about the end of the death penalty and the dying death penalty. So, and then if you look at public opinion, let's see, when in 1971 it was 49% of the public supported the death penalty. And so even then, it's like this big counter-majoritarian decision, but it's like there really wasn't a majority support for the death penalty. The country was basically split. And so then, it really does raise this question of like, okay, well, if that's true, then why did everybody freak out? And why did 35 states, even states that had abolished it themselves, were like, we want the death penalty back. You took this from us. And so what was that about? I think some people say crime rates, which I think were going up. It's definitely true. But on the other hand, crime rates were going up in the late 1960s too. In fact, Nixon's Law and Order campaign in 1968 was all about that. And Nixon did not, he ran this Law and Order campaign. 80% of the public thought crime was a problem. Gallup poll showed crime was the #1 problem in the country. Nixon did not mention the death penalty in 1968. Or in 1972. In fact, the Republican platform was silent on the death penalty. So gives you an idea of where the country was. So I don't think, I don't think really, crime rates might have gotten us there anyway, might have led to a rebound. But I think that the Furman decision itself played a pivotal role. I don't know how else you explain public opinion shifting on a dime, I think 7% in 6 months. The only thing that really changed was Furman. And much like was the case with Brown, states, I think in the South, it was definitely counter-majoritarian, right? They really wanted this. But I think there was this sort of vibe or conversation about states' rights. And so you picked up into that, and it was one thing for a state to abolish. It was another for the court to come in again and take something from the South again, and to get into criminal justice matters where the states were used to having their way. So that's my own opinion.
That's
what do you think?
pretty, I agree with you. I think it's pretty persuasive, especially that huge 7-point shift in Gallup polling from a few months before to a few months after Furman. One of the striking things is the way Nixon jumped on it once the court decided. If you can go you can Google this, the New York Times headline. This is one of my favorite lines from Michael's book, that the New York Times had a headline. Oh, this actually might be from Evan's book, or maybe it's from your book. You can tell me, maybe I'm not that well read. One of you said that the headlines for Furman versus Georgia in the New York Times, it was a banner headline, the same size as when 3 years earlier we had first landed a man on the moon. So Furman was big news. And I think it was Evan's book.
That's Evan.
That was Evan's book.
Evan Mandery's book, A Wild Justice.
Yeah, but you know why I'm thinking of your book is you describe being in the LDF office when the news of Furman came down, and quoting someone in the LDF office saying, It's like we just landed a man on the moon.
Yes, but I was not there.
You were not there. I know, you write it as if you were.
I was with my wife, who was in her 9th month in Gloucester, Massachusetts. But you are quoting correctly.
Right. So, it was big news, but on that very same New York Times page, which announces Furman, there's a story lower down on the page that says Nixon vows to bring back the death penalty for airline hijacking. So airline hijacking was the terrorism of the day. And so on the very day that Furman gets decided, President Nixon swears he's going to introduce a bill, and he does successfully in Congress introduce a bill to bring back the death penalty for airline hijacking. So, Corinna, I want to follow up with you about this question about public opinion and the death penalty. Do you think that the justices should take into account public opinion or where the country is on an issue more generally? It's a very pertinent question today where our Supreme Court is really kind of out of sync with the public on a bunch of issues. Should the Supreme Court take account of public opinion on any issues, every issue? What do you think?
I think it's another hard question. I've written a little bit about, outside the death penalty even, about the relationship between the Supreme Court and public opinion, something that I really like to think about. And I sort of think about Supreme Court decision-making as sort of this cauldron, and a whole bunch of stuff goes into that. And one of the things that I've seen, and that the political scientists have told us about for decades actually, is the stronger the ideological bent, the less the justices actually care about public opinion. So if you think about it, like Brennan and Marshall, they were abolitionists, and they were abolitionists through the 80s. Like, they didn't care that the country turned way conservative and loved the death penalty. They were abolitionists through and through. On the opposite side, Justices Scalia and Rehnquist, they were pro-death penalty. I think one of the two of them never reversed. The other one, I think, reversed in one case. You might know this, but yeah, I remember with the actual innocence movement of 2000 and 2001, and someone asked Justice Scalia, the whole country's like, whoa, let's take a pause on the death penalty. Even Republican governors, Illinois is like, oh, let's not do this. And Scalia was like, it's a human thing. People will make mistakes. So I think the more you are on the ideological edges, the less attuned to it you are. I know your question was, should they? I'm mindful of that, and not do they. The should is a harder question. And I'm thinking of Justice Scalia just because I taught Payne yesterday. To my death penalty class. So Payne versus Tennessee is the victim impact statement case. And Justice Scalia has a line in there where he says, there's a nationwide victims' rights movement, and we, the judiciary, should pay attention to it, he says. We should pay attention to it lest our inability or not paying attention to it will decrease our own legitimacy. So on the one hand, he says, yes, we should pay attention to this. The year before in Casey, on the abortion front, he says, how weird that people think that we're actually supposed to listen to them as opposed to interpreting the law. So, there's somebody saying we should and we shouldn't, depending upon what the issue is. I think, ideally, it's a court of law. It's not the court of public opinion. Structurally, it's the entire reason. It's the appointed branch. It's not elected. And the whole point of it is so that the court, the unelected judiciary, can be a counter to majoritarian overreaching. And for that, you need to not pay attention to it, right? As John Hart Ely once said, he said something like, it just makes absolutely no sense for a body that is supposed to be protecting against the majority views to be following the majority views. Like, how can you even do that? In theory, I think they probably shouldn't. On the other hand, this raises Bickel's, counter-majoritarian difficulty. If you grow too far afield, they don't have, as Justice O'Connor said, they don't have standing armies to enforce their own edicts. What they count on is their own legitimacy and people listening to what they have to say. And in order for that to happen, they can't be but so far away. So it's really super complicated. And by the way, I know you're going to move on, but I just have to say, Michael Meltsner's book, Cruel and Unusual, is what made me write my first death penalty piece and get into this field entirely. So I'm fangirling here.
Copies for sale.
I'm a fangirl too.
You inspired
Michael's
me.
fangirls. And I just want to say, I mentioned a book, I called it Evan's book, which I think is a wonderful contemporary bookend to Michael's original book, Cruel and Unusual, written in 1973, a book written from inside the LDF litigation campaign that led to Furman versus Georgia. Evan Mandery, another fan of Michael Meltsner.
Wait a
Hold on,
minute.
let me just tell him about
I have to interrupt. If we're talking books, the book you really should read is Carol's book, which, if the election in 2016 were different, might have presented the theory on which the Supreme Court would have decided to end the death penalty. So that's the book of books. Of course, that ain't going to happen, at least in the short run. And in the long run, as John Maynard Keynes said, even not only people on death row, but everybody is dead. So just if you really want to know what could have happened, that's the book to read.
Counterfactual History, Courting Death, 2016. But I wanted to mention Evan Mandery's book, because Evan Mandery tells the same story about the Furman litigation and then its retrenchment 4 years later in Gregg versus Georgia and its accompanying cases, which backtracked. But he tells the story from inside the justices' papers. Especially Harry Blackmun wrote everything down, kept every taxi receipt. I mean, he just, voluminous papers in the Library of Congress, and he was present on the court for Furman and Gregg, and also all the other justices' papers and memos that went back and forth. So Evan Mandery's book, A Wild Justice, tells the same story as Michael's book. You've got one from inside the litigation campaign, and then one from inside the justices' chambers. So that represents a really wonderful. So we can leave you with a book list when we're done. I have a few more questions that I want to ask, though. Mugambi, I want to come back to you for a second. Today, the death penalty has been abolished in law or in practice in over 2/3 of all the countries around the world. And the United States is commonly seen, correctly, as an outlier in retaining the death penalty, which is increasingly recognized as an inherent human rights violation by most of our peer countries in the world. Up until Furman, how had the death penalty in the US evolved in comparison to our Western peers, the other Western democracies? And how has it evolved since Furman? Can you give us a little context there?
For generations, the anti-death penalty movement in the United States and in Europe converged. The fundamental claims by the abolitionists on either side of the Atlantic were fundamentally humanistic claims, that it is inhumane for the government to kill a prisoner, to lower itself to the level of a murderer, that the government should lead by example, and that the law should embody humanity. The abolitionists on both sides of the Atlantic also tend to advance practical arguments, utilitarian arguments about the ineffectiveness of the death penalty, its discriminatory application, the risk of executing innocents. But what came to be is that in the aftermath of Furman and Gregg, the US death penalty debate started to focus overwhelmingly on practical considerations, concerns about due process of law, concerns about racial discrimination or the innocence of people wrongfully convicted, and arguments about the inhumanity of the death penalty, about it being a violation of human dignity, failed to gain much traction. They were the basis for two of the justices' opinions in Furman, namely Justice Thurgood Marshall, who you mentioned, and William Brennan. But the majority in Furman, Justices Stewart, White, and Douglas, focused on practical questions. And that led the debate to focus overwhelmingly on these matters. And there's also another major shift in American society at the time was the rise of mass incarceration. In decades following the resurrection of capital punishment, the US incarceration rate rises to the first in the entire world, prison population explosion, and arguments about human rights, human dignity, concerns about the well-being of prisoners, about rehabilitation, tend to be delegitimized in American society, and that shapes not only the death penalty debate, but the debate over prisoners' rights and very long, merciless sentences. But for much of history, American society actually was a trailblazer in introducing humanistic and rehabilitative conceptions of punishment. The Enlightenment, with the likes of Cesare Beccaria, was really the person who most impacted the evolution of modern criminal justice. It had a lot of impact among American thinkers and reformers in the late 18th century, from the founding father Benjamin Rush to 19th century figures like Henry David Thoreau, Ralph Waldo Emerson, suffragists like Susan B. Anthony, Lydia Maria Child, African American leaders like Frederick Douglass and Sojourner Truth, they all categorically condemned capital punishment as inhumane, as dehumanizing and wrong. And that also helps explain why several American jurisdictions also were trailblazers in abolishing capital punishment. It was abolished in the mid-19th century in Wisconsin and Michigan, and later on in Maine, and never brought back in these Midwestern states. And that was well before Western European nations. But with the rise of modernity, with the rise of mass incarceration, the resurrection of capital punishment, concerns about human rights and human dignity are often equated with European ideas or Canadian ideas or non-American ideas. But in reality, Americans historically made a major contribution to this area. It's not till modern times that the US became an outlier in rejecting these norms and embracing extraordinarily harsh, discriminatory, and counterproductive practices.
Yes, thank you so much for that needed corrective. I was telling my co-panelists, I just came back from a trip to France over spring break. And there, as a death penalty scholar, I often get the question is, why is the United States such a bloodthirsty, backward, uncivilized country so as to have the death penalty when we, the French, have abandoned it? And of course, it turns out that many parts of the US were way ahead of France. In fact, when Alexis de Tocqueville, a Frenchman, came to the US in 1830, to study the new American penitentiary and wrote his famous book, Democracy in America, he basically wrote, these Americans are crazy. The mildness of their criminal sanctions and their, urge to abolish the death penalty is just absolutely nuts. I mean, that wasn't exactly his words, but that was his take. And the founding fathers, one of their big rallying cries was they wanted to reject the sanguinary, as they called it, punishment practices of the old world. So it's hard today to remember this history, which Mugambi, thank you for that wonderful short tour of it. It's only from around 1970 to the present that we see this great divergence between the US and the rest of our Western democratic peers. And that's a really interesting story, but it's a recent story. It's not something deep in American DNA, which, as the French might have it today. So, Michael, we started with you. I have so many questions, but I'm just going to ask one more, and then it will be your turn to ask these fabulous panelist questions. So, Michael, I ask you a quick question, quick answer, just saying. I understand that you have come to believe that there is too much current lawyer talk about the death penalty that focuses on litigation and doctrine. I know you aren't advocating less vigorous defense for defendants in murder cases. So what should we be talking about?
Well, lawyers should continue doing what they're doing, but let's face it, the Supreme Court is closed. It's ideologically closed. So the notion of any significant change emerging from the judicial function is really it's more than unlikely. It ain't going to happen. So for those of you who care, who consider yourself interested in activism, it seems to me that we have to function on the cultural or cultural political level. We have to maybe follow your lead in focusing on Albert Camus and look for absurdity, irony, satire, and even at times laughter. Because the usual rhetorics are just not going to work, at least in my lifetime. Think The Emperor Has No Clothes. Think Macon. Think Andy Borowitz. That's where we have to go. I'll give you some examples in the short amount of time we have left, but really, you will come up with better ones. And if you see yourself as an activist in this area, that's the place to go. Ridicule has an enormous power. You know, when Galileo first discovered that the sun was the center of the universe, or he's following Copernicus, not Earth, he didn't go public. And the reason was not because he was afraid they were cutting off his hands or anything like that. He was afraid, historians tell us, of ridicule. We have to go there. So here's a few examples from me. But again, you will come up with better ones. So think of, it's April 25th, 1971, and Harry Blackmun is before the United States Senate. He's being confirmed. And a senator from Hawaii named Hiram Fong, he says, well, Mr. Judge Blackmun, the other day, I'm reading from the transcript, the other day you did mention something about capital punishment. When that question was put to you, I believe you stated that it might well be that the Supreme Court might say that the imposition of capital punishment would be a very cruel thing. Is that correct? It would be cruel and unusual punishment under the Constitution? Did you make that statement? In connection with the observation, this is Blackmun, in connection with the observation that the press has latched onto, I think I can quote it verbatim. I also stated ordinarily the imposition of the death penalty is a matter for the discretion of the legislature. I firmly believe this. One, of course, can imagine if a legislature was to impose the death penalty on a pedestrian for crossing the street against a red light, that might be something else again. Senator Fong, that would be very unreasonable. Judge Blackmun, I would think so. History. Took him a while to change his mind. One more example? Can I have one more?
One more.
Okay. If there's any executed American whose name you remember, it's likely to be Gary Gilmore. In 1977, he was the first person executed in the United States in 10 years. The first after we won Furman. During the time Gilmore was on death row, awaiting his execution, he attempted suicide. So what happened? Well, Utah doctors, nurses, healthcare people rushed in and they saved his life so he could be executed by a firing squad. A kindred irony, the American rule, as opposed to the rule in Great Britain, is that if you're really psychotic and thus can't be executed, well, in Britain, that's the end of you being executed. They're not going to do it. But in the US, if you recover, the common law rule quite clearly is you can go, you can be killed.
And in fact, you can be forcibly medicated to restore your mental health so that you can be executed.
I got a lot more examples, but there's no time.
And one more book, Norman Mailer's wonderful book, The Executioner's Song. It's about Gary Gilmore, the first person executed after Furman was overturned in 1976. He was executed in 1977, and Norman Mailer's brilliant book about that. It's also worth reading. Like I said, you can leave with a reading list. But now it's your turn. Who has a question for our incredible panel? We have a few minutes for your questions.
Hello. So in some countries, I'm thinking Ireland in particular, they abolished the death penalty via referendum and constitutional amendment. Do you think anything like that would be possible in the US as a potential avenue for abolition, since it does seem unlikely that the judiciary is the way to go at this point?
So referenda in US history have usually favored the retentionist camp. In 1972, in the run-up to the Furman decision by the US Supreme Court that abolished the death penalty, was a landmark decision by the Supreme Court of California called Anderson, which abolished the death penalty under California state constitutional law. and largely under humanistic grounds, that it was an affront to human dignity in California to put to death a prisoner. Not the only reason, but a big part of the reason. But in the aftermath, it was a proposition that was supported by future President Ronald Reagan to reintroduce capital punishment in California, which prevailed. So a referendum served to enact this death penalty law in California. Moreover, California would later on adopt the three strikes law, ultra-repressive punishment scheme by ballot initiative. Now, it was rolled back also by ballot initiative some years later, but the referenda usually tend to favor very harsh punishments in U.S. history. And there's also the example of Nebraska, where the state legislature had abolished capital punishment, and there was a referendum to bring it back, which prevailed.
The Nebraska story is wild. Nebraska is the first red state to legislatively abolish capital punishment in 1915. The Republican legislature, voted to abolish the death penalty in the state of Nebraska. The Republican governor vetoed that legislation. The Republican legislature overrode by a supermajority the Republican governor's veto of the legislation. So the Republican governor invested $750,000 of his own money in a referendum campaign to bring the death to, like California, Nebraska has a robust referendum initiative process. And in the 2016 election cycle, the death penalty was restored in Nebraska through referendum, largely funded by the Republican governor. So it's a wild story of Nebraska itself. There's another book add to your reading list. Austin Sarrett, a professor at Amherst College, has written a book about the referendum and the death penalty, and how basically the referendum process, as Mugambi has said, has always been on. There's never been successful abolition by referendum in the US. Direct democracy has tended to go the other way, as both the California and the Nebraska, and there are other examples too. We maybe have time for another.
Carol, can I
yes,
add,
of course.
I just
Corinna.
want to add just a little piece. Just to your question of, okay, so fine, the judiciary isn't going to do it. Don't forget about the state legislatures. Don't forget about that. Virginia just abolished the death penalty. It's the first southern state to do so, and the legislature did it. And two things about that. The first is nationally, the last Gallup poll showed that support for the death penalty is at 55%. Over the last 6 years, it's ranged between 54 and 56%. So this is like not just a momentary blip. This is sort of our new normal. That's a 50-year low. And when you're in the 50s, you are close to getting to a tipping point on the death penalty. So I'm like, don't give up. It's more like pass it on. The other thing is great capital defense. Part of Virginia's story is we had great capital defense. There weren't any sentences. Virginia didn't have a new death sentence in 10 years, had just 2 people on death row. So the death penalty was kind of already dead. But I think that there's other avenues besides the judiciary.
And let me just throw in one more avenue and a plug for a recent article that just came out a couple weeks ago by me, is state constitutional litigation. So the Anderson case in 1972 was a Tony Amsterdam special. Tony Amsterdam was litigating Furman, and at the same time he won Anderson in the California Supreme Court while Furman was pending. And of course that was reversed by referendum in California. But in the last 20 years, the death penalty has had a tremendous decline in the United States, and a lot of that has been through constitutional litigation in state Supreme Courts, Delaware, Connecticut, New York, Washington State, which abolished on race grounds a sort of anti-McCleskey under state constitutional law. My brother Jordan and I, who wrote our book together and write a lot of articles together, have an article out. He doesn't like the title. I came up with it, but I'm older, so we kept it. And the title is Little Furmans Everywhere. Yeah, you like it too, right? Little Furmans Everywhere, and it's about state constitutional litigation and the role of state constitutions and state high courts in the decline of the death penalty. I think we have time for one more question, if there are any. Anyone else have a question?
In states that have the death penalty and in years where the death penalty is very active, is there research or data that suggests that there's a corollary between high crime and violence in
Yes.
those states? That, violence begets violence?
Yes.
Is there data about that?
The answer is yes. These are states with higher murder rates.
Well, there's a cottage industry among economic empiricists on trying to prove whether the death penalty actually deters crime, whether having the death penalty makes you have less murders. And some of these econometric analyses suggest yes. Others suggest what you're suggesting, which they call a brutalization effect, that having executions increases murders. Finally, in 2012, the National Academy of Science did a meta-review of all of the studies that had been done, and there were a lot that had been done prior to 2012 that came up with both of these findings. And the National Academy of Science Blue Ribbon panel said basically there's no evidence that the death penalty deters murder, but they also said there's no evidence that it does not or that it does anything else. Basically, the absence of evidence is not evidence of absence. So basically, they said empirically it's a stalemate. We just can't tell anything. None of these studies prove what they suggest. So the question for us, and I will leave it here and let Jocelyn close this out, the question for us is if we don't know, and we don't have adequate evidence or studies to know whether the death penalty makes us safer or less safe, if that's just, we just don't know, then we have to decide the question on other grounds. And I think that's where I'll leave you today. Can I just ask you to join me in thanking this incredible panel?
Thank you so much. Thank you all so much. That was, I wish we had like 4 more hours because I feel like there's so much more that we could talk about. This is our last big panel of our death penalty series, but for April 3rd at 4 p.m. in the library. I'm super excited about this. Members of Carol's capital punishment class clinic are going to be coming to the library and talking about the work that they've been doing over the last year or two for the capital punishment class. So I hope that you'll come join us for that and sort of hear what the next generation, the future Michael Meltsners, are working on today. So please join me, and please again thank our panel for being here. Thank you so much.